This recording will help give you an introduction to one of the first topics we're going to look at in civil procedure jurisdiction, that being subject matter jurisdiction. And we're going to take a brief look at what subject matter jurisdiction actually is and a look into how to think about the interplay between the United States Constitution, Article 3, Sections 1 and 2, and the congressional grants of jurisdiction, the first one being diversity jurisdiction. So what is subject matter jurisdiction? Well, we need to break apart those words, subject matter and jurisdiction. Subject matter essentially is the dispute itself or the remedy the parties are seeking. So when we say we have subject matter jurisdiction, part of that is referring to disputed matters or the actual remedy being sought. The other aspect of jurisdiction is the power. It refers to the power of the court. So if we think of it all together, subject matter jurisdiction means the court's power or authority over the dispute or the remedy being sought. Subject matter jurisdiction is the court's power or authority over the disputed matter or remedy being sought. A court, whether that be federal or state, must have subject matter jurisdiction over the case before it. In this course, we're going to focus primarily on federal courts, but it's helpful to take a little bit of a look at the distinctions between federal and state court. There's a couple principles that flow from the concept of subject matter jurisdiction and the idea that it's the court's power. One is that we never presume in federal court that there is subject matter jurisdiction of the controversy. If you recall from civil procedure rules, the complainant in his or her complaint, the plaintiff, had to allege the basis for federal subject matter jurisdiction in order to get into court. We also never allow parties to consent to federal jurisdiction. That means essentially as disputants, we couldn't say, well, I'm not sure, or I don't even think the federal courts have subject matter jurisdiction, but we're both going to agree to not raise that and to just agree that this court will be okay for our controversy. It's not something the parties have any control over. It's the court's power itself. The parties cannot give the court authority. The court's authority comes from other things, namely what we're going to look at in just a moment from the Constitution and for federal courts and from Congress. So parties cannot create this form of authority. That also means they cannot waive an objection to subject matter jurisdiction. In fact, we'll learn next week when you read a very famous case that subject matter jurisdiction can be challenged for the very, very first time by the court itself in an appeal before the United States Supreme Court. So this is something that is really important to make sure we establish correctly at the beginning of the case. So here's a little introduction to subject matter jurisdiction in the federal courts and the distinctions between federal courts and state courts. The federal courts are comprised into appellate courts, which you see by the numbers here. There's called circuits, and there's several circuits here. We're in the 6th Circuit, which includes Tennessee, Kentucky, Ohio, and Michigan. Within the circuit, within the appellate circuit, you have several districts. Those are delineated on the map, and there's a clearer version of the map in your casebook by the dotted lines. Some states with more dense populations have multiple districts, like Ohio. We have the Northern and Southern District of Ohio. We currently, in Columbus, are sitting in the Southern District of Ohio. We'll talk more about these distinctions as we continue throughout the course. You'll notice on our map that some of the states out west don't have any dotted lines within them. That means that the state has only one district. So for example, let's take Wyoming. Wyoming has the United States District of Wyoming, and there's no southern, northern, eastern, western, or other division, or other district. In federal courts, and let's presume we're in the United States District Court for the Southern District of Ohio, we have what we refer to as limited jurisdiction. And this means that the federal courts can only hear the cases that Congress has affirmatively authorized them to hear. So it's very small, a lot smaller than you might otherwise have realized. There's a lot of cases that still come into federal courts, but their reach is more limited than the state courts. So we refer to federal courts as limited jurisdiction. There are a special few select things that the federal courts are places the only place we want something to be heard. So Congress might confer what we call exclusive subject matter jurisdiction over a certain kind of case in federal court. And you may think for a second about what that might be. Can you think of anything the federal court or Congress would have wanted the federal courts only to have heard? Take a moment, actually think about it. What do you think? What might we only want the federal courts to hear? Well, one thing we might only want the federal courts to hear are things over which we consider we need to have actual federal control over. So, for example, copyrights or patents. It would be very difficult if we had a lack of uniform law created across the country on something like patents. And so those things have exclusive jurisdiction within the federal courts, meaning you can only file them in federal court. Most things in federal court, however, are not part of the exclusive grant of jurisdiction and are rather things that we call concurrently jurisdiction, meaning you could file them in either the federal or the state courts. Just keep in mind the federal courts are limited. State courts, on the other hand, have what we call general jurisdiction. This means the doors are fairly wide open to state courts. Can you think of the only things that can't be filed in state court? That's right, things that are exclusively granted subject matter jurisdiction to the federal courts. All right, so let's take a moment and test yourself. I'd like you to go ahead and take a break, run through this multiple choice question, and I'll give you the answer. So here it is. Which of the following statements is false? A, state courts typically have general subject matter jurisdiction. They can hear cases involving any subject. B, federal courts have limited jurisdiction. They can only hear cases involving subject matter jurisdiction that the Congress has affirmatively authorized them to hear. Is it C, courts or sometimes Congress has conferred exclusive SMJ on federal courts. They alone can hear the case. Or D, there is never concurrent jurisdiction, i.e. a claim may never be filed in either state or federal court. So you know, of course, the answer that is false is D. There are many cases, in fact, in which you could choose between federal and state court. And the idea that you have this choice is something that's important to you and to your clients. If you can choose federal or state court, you need to understand what the advantages might be of one court system over the other. You've already spent some time learning a little bit about the processes in federal court. We're going to spend more time talking about advantages and disadvantages to filing in federal and state court in the class. In fact, in our first day of class, we're going to take this issue head on. Let's focus a little bit now on Article 3, since this is one of the bases for getting into federal court, or where the power of the federal courts stem from. So this is from the Constitution, Article 3, both Section 1 and 2. Let's look at them. Section 1 says the judicial power of the United States. Now, if we stop right there, we know from this initial part of the clause of the Constitution that we're talking about the judiciary and we're talking about the federal government. So the judicial power of the federal government. And then the next part tells us more. Shall be vested in one Supreme Court. Shall means must, right? Must be vested in one Supreme Court. And in such inferior courts as Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. So if you look at Section 1, there's two important, there's actually multiple clauses that are important, but two big sentences. The first sentence deals with the power of the courts. It also tells us what courts are required and what courts are not required. And it tells us a little bit about the authority of judges and what their time on the bench might be like. So let's take a look at this question and see if we can figure a little bit out about that last sentence. And I apologize for the typo in A. Which of the following is false? Article 3 mandates the existence of the U.S. Supreme Court. B, Article 3 mandates the existence of the lower federal courts. C, Article 3 empowers Congress to create the lower federal courts. Or D, Article 3 mandates that all federal judges enjoy lifetime appointments and no decrease in salary. The correct answer is B. This one surprises people often, I think in part because they're looking at the language shall and not understanding where it is designated within the first sentence in Section 1. And I'll flip back to that in just a second. All right, so if we look at the judicial power of the United States, it tells us it shall be vested in one Supreme Court. That's why answer A is actually true, that Article 3 mandates the existence of the U.S. Supreme Court. You see in this sentence that the Supreme Court has been established by the Constitution, and Congress cannot take away the Supreme Court. The rest of it says, and in such inferior courts as Congress may from time to time ordain and establish. That portion tells us Congress may choose to create or even dismantle, get rid of the federal courts. They have the power to create and take away the lower courts. So Congress could, if they wanted to, for example, get rid of all the lower federal courts, district courts, and appellate courts. Realize this would probably be a politically unwise move, as it would create a huge overburdening in a lot of ways of state courts, and for things that of which we currently have exclusive jurisdiction in federal courts, we would likely not have a venue to bring them. But we do, if they do destroy them, we would have the venue of state courts for all things in which concurrent jurisdiction would be applicable. All right, that's why B is wrong. Let's look at another question, based on Section 2. So let's look at Section 2 now. Section 2 actually refers to what the power of the courts will be in controversies and cases. So this really is about subject matter jurisdiction. It says the judicial power shall extend to all cases. Remember, I told you subject matter jurisdiction is the court's power over the matter before it, over the dispute or the remedy. And so that's what this section is telling us. The authority that we have under Article 3 shall extend to cases and law and equity, and then it gives us a whole list. And we're going to spend several weeks taking apart this list, all right? But just what we're focusing on for today is that the judicial power extends to those cases. But what does that really mean? Let's look at another question. Which of the following is true? A, Congress may permit the federal district and federal appellate courts to hear all the types of cases listed in Article 3, Section 2. B, Congress must permit the federal district and federal appellate court cases to hear all of the types of cases listed in Article 3, Section 2. Or C, Congress has permitted the federal district and federal appellate courts to hear all of the types of cases listed in Article 3, Section 2. The correct answer is A, Congress may permit the courts to hear all of these cases, but they need not if they choose not to. And how do we know that? Well, this is the part that confuses most students. If you look at it, it says the judicial power shall extend to all cases. And this is the point where students sort of get up in arms and say, you just told me that shall means must. And I've heard that from multiple professors, so I know that the judicial power must extend to all these cases. And that is true, that the power itself does go to all those cases. But when you read Section 1 and Section 2 together, you have to understand that while the power shall extend, the power itself extends to all those cases. Congress has authority over the inferior courts, the district courts that we're going to be talking about throughout the semester, and the appellate courts, and they can choose to shrink the power of the lower courts to something less than the full extension of Section 2. Section 2, if you really want to think about it, is the maximum we possibly could go to. And Congress can choose to go up to that amount for the district courts, but they need not to. So you really need to read Section 1 and Section 2 together. And I realize that's a point of confusion, but it does mean that Congress may permit the extension of subject matter jurisdiction to the full extent of Section 2, but they don't have to. It also means that option C has also been wrong just based on what Congress has done. Congress has not at this point permitted district courts to hear all of the cases listed in Article 3, Section 2, or at least hear them to the full extent that's permitted under Section 2. And that's a lot about what we're going to learn about. What has Congress actually permitted? What doesn't it permit? And try and work from there. So for people who like visual representation, let's think of it this way. Here's a Venn diagram. The yellow circle is the congressional grant, the statute itself that Congress says, okay, we're creating a district court and here's what they can hear. The pink circle represents the constitutional grant under Article 3. So we think about it this way, the overlapping section where the Constitution both permits and Congress has now authorized is where subject matter jurisdiction actually exists. It needs to fit both Article 3 and the statute. If the statute goes beyond what the Constitution permits, it would be represented by the lower part of the yellow circle and be an unconstitutional grant. And sometimes the Supreme Court has struck down statutes as being unauthorized grant of subject matter jurisdiction. What's more likely and has happened is that Congress has really shied away from going to the full extent of the Constitution. It has opened up in certain cases the full extent of the Constitution, but not in all. And so we're going to see the limits that Congress has imposed and where we could still reach into. So it would still be okay if the bubbles should entirely overlap, should Congress decide to say everything in Section 2 is permitted. But currently, right now, they don't. And so the only things that we're going to get access into court are the ones where the Constitution allows it and Congress has actually authorized it. All right, I hope this is helpful, and this is really fundamental stuff that you need to know for the rest of the semester. So I would encourage you to come back to this video in the future just to help you refresh on some of these basic concepts.